Okay, good afternoon, everybody. For anyone that has yet to participate in one of our Refugee Summit webinars, my name is Stephanie Morris, and I am the director of the Refugee Alliance of Central Iowa. Just really quick, wanted to say thank you to everyone for being here today. I know that there is quite a bit going on currently, just with other meetings and other activities that are going on today with the election, and then everything out, and then COVID and everything else that we all do daily, regularly. So thank you very much for being here today. And I wanted to say thank you as well. Oh, and then also from Rossi, we have Valerie Bouvat de Virginie, who is the Rossi AmeriCorps Vista. And if anyone has questions after the webinar or is needing to connect, or if there's anything that we can do to help with action steps after this webinar, you're welcome, as always, to reach out to either of us, and we're happy to answer questions or connect you with people that are that you're looking or hoping to connect with. So today, the webinar focus, the topic for today that we're focusing on is understanding and protecting workers' rights. And then with us today, we have Robin Clark-Bennett, who is an educator with the University of Iowa Labor Center, and then Jennifer Sherer, who is the director of the University of Iowa Labor Center. And just for those that may not know, Robin, since joining the center in 2008, has taught hundreds of adult education classes on worker rights. I think there's a lot of us here today that have actually been in webinars or meetings in the past since March, since COVID in particular hit. And she probably is looks familiar to many of us, but she's taught classes in labor history, leadership, policy topics, and then in communities across the state. She served as a lead instructor for a 2010 to 2012 Department of Justice funded public education project on anti-discrimination rights of immigrant workers, and has continued to coordinate public conferences and develop community-based worker rights workshops that are accessible and relevant to immigrant and refugee community members. She has a bachelor's in history from Yale. She worked for 15 years as a labor organizer in New York, in New England, and the Midwest prior to joining the Labor Center. She speaks Spanish and English, and is a founding board member of the Center for Worker Justice of Eastern Iowa, which I think has also some of our network has been involved with as well. And then Jennifer is the director of the Iowa Labor Center. She's got 15 years of experience in teaching, facilitating workshops, coordinating projects on workers' rights, labor history, union leadership, and labor policy subjects. She also directs the Iowa Labor History Oral Project and has served on the boards of the University of Iowa Center for Human Rights, the Iowa Policy Project, which is now Common Good Iowa, and the Labor Studies Journal, and is a delegate to the Iowa City Federation of Labor and volunteer for the Center of Worker Justice for Eastern Iowa. She first became active in labor movement as a graduate student, serving as president of UE-COGS Local 896, a project staff organizer for UE, and a leader of student anti-sweatshop campaigns while earning a PhD in English. She believes strongly in the power of popular education to transform people's lives. And then I will turn it over to both Robin and Jennifer, as I know that you're all here to listen to them and not me. But again, if you have any questions throughout the presentation, you're always welcome to write into the chat, and we can be sure to get that out. All right, Robin, I'll turn it over to you. And Jennifer?
Thanks, Stephanie.
Sure.
So we're going to start just by giving you a quick introduction to what the University of Iowa Labor Center is and does. And actually, I think Stephanie's introductions gave you a nice quick glimpse of some of who we are. So Robin and I are 2 out of 4 educators who work at University of Iowa Labor Center. And Robin, if you want to click down through You will see the pictures of not just us, but our two colleagues. All of us at the Labor Center come from a labor background. And I'll just say hello from our other two educators, Paul Iverson and Guillermo Morales, who both have legal backgrounds and also significant experience working with and for workers in a variety of sectors. So all of us are educators who specialize in various aspects of workers' rights, and we do work closely with students and faculty members on our campus, but really the Labor Center has a statewide mission and has had a statewide mission since it was founded in the 1950s to reach adult workers where they are and with information that is relevant to their work lives and to improving the quality of their jobs. So we do classes that are focused on workers' rights, which is mostly what we're going to talk about today, other labor-related issues. We also support organizations who are working to develop their leadership capacity from the ground up on a grassroots level. And we also, this past year, launched a very, so far, successful pre-apprenticeship program, which is designed to specifically recruit women and people of color, including first-generation immigrants and refugees, into skilled trades apprenticeship programs. And we're partnering with building trades unions all over the state and making those connections with folks. So keep going to the next slide here. So as I mentioned, one of our priorities is to reach workers where they are, and that means trying to design curriculum that is accessible and also delivering it at times and places that are accessible to workers. So in non-COVID times, we would often be traveling quite a bit and doing in-person classes in just about every region of the state. And right now we're doing those mostly on Zoom and learning how to try to do that effectively to keep people connected to this information. We do have capacity to deliver classes ourselves in Spanish. We've got 2 educators who are Spanish speakers, and when people need access in other languages, we do have the ability to deliver classes using simultaneous interpretation. And our goal always is to try to match the learning experience to practical needs that workers have. And really, a lot of what our classes are designed to do is based on the popular education method of trying to figure out what the problems are in collaboration with the learners, the adult workers who are participants in our courses. So what we're going to talk about today is giving you really just a first glimpse of some of what it might look like when we engage workers in discussion about how legal rights might be relevant and applicable to situations they're encountering in the workplace. And in the US, there's a long history of where these laws we're going to talk about came from, which we won't delve into in a lot of depth today. But one important concept that really frames all of what we're going to discuss is the reality that in the US, we have what's called an employment at will system. And that creates a certain kind of imbalance in the employment relationship from the beginning, which is just built into our legal structure. So in other words, the employment contract in the US typically means that in theory, workers can decide whether and when they want to accept a job or stay at a job. And employers, likewise, can decide when and whether they're going to hire or retain an employee and can let them go at any time. So that's the employment at will doctrine. So unless there's some other law or there's a contractual relationship or contractual agreement or collective bargaining agreement that a union has negotiated with the employer, in the absence of any of those things, management makes decisions about all terms and conditions of work and can also decide whether to promote or demote or discipline or terminate somebody's employment for no reason. Or with any reason that they want to decide. So what we're going to talk about is what are those other laws or structures that do create some parameters around the decision making that management makes, and that our have been over time in our history designed to create some floor, some at least minimum standard for what most of us hope is the fair treatment that we would like to see in our work lives and in other people's work lives. So what we're going to be talking about is a very, very complex patchwork of laws that have sometimes been passed on the state level and sometimes on the federal level. All of them emerging from, in many cases, long struggles, and in some cases, political compromises that have given rise to them. So again, I want to mention that we've got
sorry, I had some noise in the background.
Much more detailed resources.
This is Bureau of Refugee Services. Lauren
I don't know
Vaughn.
if you've got the ability to mute, so we're not, oh, there we go. So what we're gesturing toward today is covered in much more detail in resources that we also have available and make available to leaders and advocates on our website through, there's a picture here of our Iowa Worker Rights Manual that covers each of the laws that we're going to talk about. And we're going to do this through thinking about some real life scenarios, which is often the best way to delve into a complicated group of overlapping and sometimes confusing laws. So what we want to do is really talk with workers about where the rubber meets the road. What are you experiencing, and what questions do you have about how your employment should be handled? So I'm going to turn it over to Robin for the first example here.
Great, thank you, Jen. So we're going to look at just quickly touch upon 5 real life scenarios that we've encountered, particularly in immigrant and refugee communities in Iowa, although certainly not unique to those communities or exclusive to those communities, but to begin to assess what are the kinds of federal and state laws that may apply to very common workplace scenarios. Unfortunately common in cases like this one. So ABC Cleaning hires Carmen to clean a large restaurant alone after closing 7 nights a week. The restaurant manager provides the cleaning supplies and gives her specific instructions about how to do the job. It takes at least 6 hours a night to complete the job. ABC agrees to pay a flat sum of $900 per month, but at one point the checks simply stop. Months later, she's owed for 49 unpaid days of work, and the owner of the cleaning company has disappeared. And I'm just going to ask you to either through chat or unmute yourself and say just from what you already know about laws in our state and federal system, what are some of the laws you think would apply to this scenario? And I would invite any of the participants to just jump in and throw out some ideas. Does anyone have any ideas what laws might be at issue here?
Sorry, I was a little late. This is Lata DeMello from.
Hi, Lata.
Hi, Robin.
What do you think? What are some of the laws that might apply to this situation?
I think that's exactly what Jess Johnson now sent a message, but also it's illegal, I know, but I'm trying to figure out, remember, which were the laws that were violated. And especially if the person, the cleaning company owner has disappeared, there's even that also. How do you, where would you get your the violations addressed? So I'm trying to figure out, just because I joined, but which one?
Yes, absolutely. And as Jess says, wage and hour laws exist at both the state and the federal level. And so part of the challenge, I think, is, and this is what our workers' rights manual that we have available on our website in English and Spanish at this point really begins to compile is, what are the state laws and what are the federal laws and where can you go to enforce them? So if Carmen is an employee, and actually in this real scenario, the contractor had further complicated the situation by saying that she's not an employee, she's an independent contractor. But there were some clues in this story, and as the organization working to support, the real woman's name was Kosiwa in this situation, as this scenario in the organization found, there were some clues that really demonstrated that she was an employee. She was told how to do the job, when to show up, provided supplies, provided supervision. She was not her own cleaning company. She was paid wages, even if they were sort of incorrectly paid as flat wages. And so that is an important question for most labor and employment laws is, first of all, is the person an employee? Because under our system, most of the time, independent contractors who truly are their own subcontracted companies are not covered by these laws. So she was considered an employee. And in that circumstance, that flat rate she was paid per month, compared with the hours that she worked, did not live up to even our quite low state and federal minimum wage. And so that was, first of all, a violation of minimum wage at both the federal and Iowa level, a violation of overtime rights. So under federal law, employees must be paid time and a half after 40 hours in a week, and she was not receiving that. And a violation of our state laws regarding wage payment processes. So these were not timely payments. Certainly, the 49 days unpaid was far from a timely payment under our state legal requirement that workers must be paid within 12 days of the end of the payroll period when the work was performed. So 3 issues at least in this scenario. And it really speaks to, often in these kinds of cases, known as wage theft cases that have really shockingly reached epidemic levels in our state and across the country, and undermine the work of reputable employers, as well as obviously having really serious impacts on workers' lives. That part of the challenge is piecing together the evidence. And so, some of the issues that we would talk to people about and the resources that we would talk with people about in these kinds of classes is how to track your hours to be sure that you have a clear record of when you began work, what breaks did you take, when did you leave work each day. So even if there is not an official pay stub, as there should be, and you're required to have under law, you have your own record. And if you do receive a pay stub, you have something with which to compare your pay stub. We also have a tool that we like to use called Dissect a Check that just walks people through each of those sometimes confusing categories in a pay stub so that people can determine whether there were unlawful deductions or other violations of the law. So who can help Carmen recover her unpaid wages in this scenario? You can file complaints of the violations of federal law with the U.S. Department of Labor, that Wage and Hour Division, the state law violations with Iowa Workforce Development. You can actually pursue this type of right through a private attorney or legal aid. And you can reach out to worker advocacy organizations. And there are many organizations in the state of Iowa who've provided support for workers so that they're coming together and they're not alone when they approach their employer to, really demonstrate that this is a community issue and that the public expects employers to abide by these fundamental workers' rights. And many times people take more than one of those approaches. They might file the complaint, but also reach out to a worker advocacy organization to really sort of through both avenues assert their rights. I'm going to pass it back to you, Jen, for the next one.
Thanks. So in this situation, Bradbury has worked in a meatpacking plant for 2 years. Due to a high number of absences during the COVID-19 pandemic, workers are struggling to keep up with the production line. He has a history of kidney problems, but his supervisor told people not to leave the line to use the restroom until their scheduled break time. So days later, a doctor finds that Bradbury has a kidney infection and prescribes rest and antibiotics. So Bradbury calls in sick, doesn't go to work, but later finds out when he comes back to work that he got 3 attendance points for the absence. And if he gets 1 more point, he's close to termination. So in other words, he could be fired. So what thoughts do people have about what Brottery should consider in this situation? Are there any laws or legal rights that might help support him here? So somebody typed in OSHA. Jess did already. And it sounds like that it could be relevant. So OSHA, Occupational Safety and Health Administration, is the law. And in Iowa, we have a state OSHA program, which is linked to the federal OSHA law and required to be at least as effective as the federal OSHA system. And that is a law that is requires employers to provide what's called a safe and healthful workplace for employees. And so, Jess, I'm guessing maybe you raised that because of the issue of whether it's healthy or safe for somebody not to be allowed to use the restroom. And in fact, this is an issue that workers contend with, especially in certain occupations. Drivers contend with this, certainly, where they don't have the opportunity to use restroom facilities when they need to during the day. People in production facilities with high production speeds and pressure to meet certain quotas can contend with this. Lots of occupations. Teachers, you can imagine, sometimes contend with this. So federal and Iowa OSHA standards do protect workers' rights to leave the work area to use the restroom. So that is one thing that might be helpful for workers in this situation to know. And because in this situation, the worker has a significant health issue, we don't have all the details in this short scenario, but depending on a person's medical condition, if that condition rises to the level of a disability, the Americans with Disabilities Act may come into play as well. And that is a law that is intended to protect people with disabilities who are qualified and capable of doing their jobs, but need what's called a reasonable accommodation to continue to do them. Employers are required to go through a process of trying to find a reasonable accommodation. And so the example on the slide here, relevant to the situation, is that it may very well be considered reasonable for this employee, for Brottery, to have not just the usual restroom access with every employee is entitled to, but maybe because of his kidney problem, he should be granted unrestricted access. Keeps him in the workplace. He can continue to do his job as long as he's not endangering his health. And
so Jennifer, can I ask a question here? So is the company expected to make a list of what could cause people to lose their attendance points? Or have these sort of, is that a requirement, or is that what we are as people who work for workers' rights say this is what is needed because we could look at that as something for companies to follow, right? Having those, all these rules put out over there.
That's a really excellent question, Ada, and we should back up to pause and talk about those attendance points for a second. So it sounds like in this situation, the attendance plan or attendance policy that the company has, it's very, very common in hourly workplaces.
Yes.
It's sort of what they call a no-fault attendance policy. So in other words, if you miss an hour or miss a day, there's a list of how many points you might be assigned for that absence. Doesn't matter why you were gone. You could have had a flat tire, you could have gone fishing, you could have been so sick that you couldn't come to work, right? No matter what the reason is, those points are assigned and they add up over time. And if you hit whatever the certain number is in the points, you might get disciplined. And if you hit a higher number that's in the list, then you lose your job, right? So
and that's legal.
Yeah,
are those attendance points legal?
So the having attendance plan structured like that is considered legal, except, and I think that's the question, the very good question you're asking, except for the sorts of exceptions,
Yes.
what might, and that's why we're throwing this scenario out exactly. And you're also right that, ideally the employer communicates and makes clear that there are some exceptions, but it's not necessarily required
Right.
that that communication takes place in conjunction with the attendance plan. And I think that is part of why our system is so difficult for all employees to navigate, and particularly people who are new to the workplace or new to the US on top of it.
Yes.
It's a lot to take in and understand. So I think to answer your question, fundamentally, it does end up typically being quote unquote our jobs collectively to educate people on what some of those rights are. So
Yeah, and
yeah.
exactly. And sorry to interrupt, but I
Mhm.
know I've had these situations where interpreters will go into new jobs with our clients we serve, and then nobody quite knows what is said actually and shared. And then, employers think they've done their job, and that's that. So these
Yeah.
are situations that have arisen after that, following that.
Yeah.
Thank you.
Yeah, and the standard to communicate about the basics of the state and federal laws is fairly low. In
Mhm.
many cases, it's include a poster
Right.
somewhere.
Right.
May or may not be translated into all the relevant languages, or include a mention of it in an employee handbook, maybe, which might be made available to people on paper, but might also just be on a website that people would have to go find. Right, so the information is not always clear and accessible. And then the last law that was on that list was the Family and Medical Leave Act, which is designed to protect people with what are called serious health conditions from um, uh, losing their jobs or being disciplined if that's the only reason they're gone. If the reason if the reason for their absence is linked to their serious health condition, they have a limited amount of unpaid leave that is protected up to 12 weeks. So that's another, it would be a good question. If we had the opportunity to sit down and talk with Bradbury, we would want to ask about the medical treatment that he's receiving, and if his condition is a serious health condition under FMLA, then assist him in talking to the HR department about applying for that protection. So who can help with this problem? Lada, I think you helped answer some of that question already. In some cases, it's community advocates and other organizations who step in and support and assist folks. If there is a union present in the plant, in the workplace, then typically there are union stewards who know lots of this information ideally and are positioned to help people navigate and go to talk with it to HR with them or on their behalf. In the case of some of the laws we talked about, so OSHA in Iowa is administered by the Division of Labor under Iowa Workforce Development. And so workers have the right, if they have a health and safety concern, to file complaints with that agency, the state agency. The Americans with Disabilities Act is part of our non-discrimination laws, and so it's covered by both our state Civil Rights Commission and the federal Equal Opportunity Commission, the EEOC. So if somebody pursues with their employer the discussion about needing a reasonable accommodation and runs into a roadblock or doesn't feel that their disability is being addressed properly, those are the agencies that they could pursue. And FMLA is administered by the Department of Labor on the federal level, and there is the opportunity to file a complaint there if you don't have local assistance. And people also have, of course, the right to seek legal assistance or to consult legal aid.
Sorry, I have a quick question. Actually, if you are getting to it, Robin, because it had to do with one of the previous case, and maybe I will bring it up. But because I have a client, undocumented and trafficking issues, but was being paid with a personal check, not a payroll check. Is that something you all will address now, or is that something that? you know, like, how is it that when people use personal checks to pay, you know, what does one do if there's no payroll check? So you know that it is all, and especially if it's for
Yeah.
someone who's undocumented, it's so tricky. So
Yeah. So I will say, and we'll emphasize this again at the end, that most of the laws that we're talking about do apply regardless of status. And that's, you know, obviously incredibly important to not create a giant loophole, you know,
Right.
that would excuse cases of really flagrant abuse. And so, so the immigration status of the person is not an issue under the law in terms of their right to those to certainly wage payment rights is a really important example of that. And the payment of a personal check would certainly, if there's no pay stub, for example, that violates Iowa Wage Payment Collection Act. And then there are tax implications and in terms of tax law as well for that. And it sort of connects with what Stephanie was asking too about the consequences of violations of those laws. So that depends a little bit on how people pursue their lost wages. If people pursue the help of a lawyer and file a private right of action, then if it's a willful case, if you can show the employer knew and intended to not pay those wages, which is quite clear in many cases, then the person's entitled to liquidated damages, which usually are about twice the wages that they were owed, as well as payment of attorney's fees.
Okay.
And through agencies, there are sort of a menu of options, including fines. But what we typically see is that what people could expect in a successful case, if the agency pursues it to its conclusion, is just getting exactly the wages that they were owed. So
Okay.
unfortunately, fines and an
Okay.
additional payment are very rare when it comes to agency enforcement of wage payment laws. One of the reasons that people also often request and escalate to sort of more public responses is also sort of that shining a public spotlight does matter in ways that are beyond just simple economics to and can persuade employers to treat people differently and in compliance with the law.
Thank you. Sorry.
No, that's a wonderful question. Thank you. So we're going to look at a third case, which is Hanadi works at a group home for people with intellectual disabilities. And during her shift, a resident injured her hand. She reported the incident to her supervisor, but did not go to the doctor initially because she thought it would simply heal. Her hand continued to swell. A week later, she went to the doctor and discovered it had been broken. The supervisor said the accident was Hanadi's fault for not being more careful and for waiting to go to the doctor. But he said to be kind to her, he offered to pay half of her medical bill. What is the law, do you think, that's at issue here? Anyone have any guesses? I suspect you do know this one. So as I suspect many of you were thinking, this is a classic violation of workers' compensation law. Those are state level laws. And so Iowa, like other states, it's a no fault insurance law. So workers receive compensations for injuries on the job, whether or not it was their fault. And they have a right to payment of medical care and expenses related to work injury, partial replacement of lost wages due to that injury if they're required to be out of work as part of their healing process, as recommended by a medical specialist, and for compensation for permanent injuries. And so this system basically replaced, you know, a much earlier 100-year ago system of people pursuing these cases through the courts. And on the upside, provided more assurance that regardless of fault, workers can be assured that they get payment and payment of some of the lost wages, as well as payment for the medical care that they need to receive. On the downside, the compensation is quite limited based on a schedule of payments and based on the wages that they actually received. Workers have to report the injury within 90 days to qualify for this law. Company policy may say you have to report earlier, and that could be a basis for discipline or termination of the person if they haven't done that, but it's not a basis for denying them their right to compensation under the law. So who do you reach out to is the Division of Workers' Compensation exists within Iowa Workforce Development, the state level. In most cases, it is recommended that people work with a private attorney or with legal aid because it can be a very difficult process to navigate if the employer is contesting their claim.
All right, so we're going to go to example number 4. In this case, Sarah is working in a nursing home as a CNA, and she is also a union member. She takes her job seriously and gets excellent reviews, but the manager doesn't like her, and she's given more work than the other staff. Last week, Sarah received a 3-day suspension for not finishing an online course on time, which usually isn't something that people are disciplined for. Her coworker is behind on 2 online courses, but she wasn't disciplined. And people say that's because she's the manager's daughter, which might be true, but Sarah is also the only person of color in the workplace. So what thoughts or reactions do folks have to this situation? There's a lot going on here. A soap opera of sorts, probably. But in terms of what legal rights or options Sarah should consider or find out more about, what would you recommend to her? So there's a couple things right off the bat that we might want to consider. And these are always some of the most difficult situations to talk through with workers where they're experiencing something that feels like disparate treatment, feels like a form of discrimination, and they have growing evidence of differential treatment that they're experiencing. The reality of our legal system, to go back to kind of where we started, is that typically differential treatment in the workplace is actually not illegal. One employee can be given one assignment and have the same job title as the person next to them, and the person next to them can be given a different assignment if that's what management decides on a given day, unless there is discrimination going on that is attached to a prohibited form of discrimination. And a lot of us know this mantra of race, color, religion, national origin, or sex, the categories of identity that are protected from discrimination under the Civil Rights Act and under our state Civil Rights Act as well, which has expanded on those categories even a little bit beyond our federal law. So one question we would have to ask in talking more deeply with Sarah is about whether this discrimination that's happening is linked to, in this case, her race. Because one fact we already know is that it sounds like she's the only person of color in the workplace. And is there evidence that we can help her document or sustain that would help make that case? And if so, she should pursue potentially a discrimination claim. Now, in this case, Sarah is in a unique situation. The majority of healthcare facilities in Iowa are not unionized, but she is in one that is. And that also gives her a different form of protection than the majority of workers have, because unlike differential treatment that is perfectly legal in most workplaces, under a union contract, typically workers have protection against discipline unless the management has good cause or just cause to discipline or change your work assignment or give you more work than everyone else. So if that form of mistreatment is happening, she should talk to her union steward or her union officers. And they, if things are going well, and they should follow up and investigate and find out if there's disparate treatment and punishment that's being issued to her that's not for just cause. In other words, it's not equivalent to how everybody else is being treated. Union contracts typically also have a non-discrimination clause of their own, and that's another way that if she has a union available to her, they could get involved and protect her from the mistreatment. So who can help? I think we mentioned some of those along the way, that the discrimination laws are under the purview of our state civil rights commission, also our federal EEOC. Again, if she doesn't get help some other way, workers do have the right to seek legal action privately. We often say that's the last resort, because if there are other options to resolve it more quickly and without a lot of cost involved, those other local options are almost always better if you can get a resolution that way through the union or through assistance of your coworkers or one of the state agencies. And Mohammed asked a good question too about discrimination for age, and that is another protected category that has been added to our civil rights laws with further statutes. So if you're interested in that and some of the other anti-discrimination laws, I would refer you back to the link to the worker rights manual that goes into each of them.
Great. So our last case scenario we're going to take a look at here is that Irund was hired at a large factory that employs 600 workers. He's a native French speaker, like many workers there. When he was hired, the HR director insisted he provide a birth certificate, even though he had shown his social security card and driver's license, which met the Form I-9 requirements. And I should specify in this case the unrestricted social security card. The manager brings him to the office for periodic work evaluations, but the manager only speaks English and there's no interpreter available on his shift. Irund doesn't feel very confident that he understands all the instructions in the meeting. So what do you think, through chat, typing in the chat or speaking up, what are some of the legal issues that might be wrapped up in this case? Does anyone have any guesses?
Is it Title VI? Is Title VI ever part of this? LEP?
Well, that's there are a couple of examples that I really want to highlight. And actually, there could be additionally other discrimination, for example, related issues involved if they are only asking for documents of based on people's race, based on people's ethnicity. The two that I really want to highlight are the anti-discrimination provisions of the Immigration and Nationality Act, which is actually a piece of federal immigration law that recognizes that by having employers engage in the I-9 verification system, we're really sort of deputizing employers to take on a function that they may not know a lot about when it comes to the intricacies of all the various forms of identification that people are allowed and authorized to show, and that there could be discrimination in part of that process. And so this section of the Immigration and Nationality Act prohibits discrimination on the basis of authorized workers' immigration status and unfair practices when workers are showing those documents. So workers are allowed to show whichever documents they choose from among those allowed in the I-9 form. And so if you need to show one from one column and another from another column, the worker has the right, not the employer, to choose which of those documents they're going to show. So if they've shown documents as required by the form and they've shown, enough to meet the qualifications of the form, then the employer is not allowed to require more because the person appears to be, an immigrant or appears to, for whatever reason, that beyond just the reasonableness of the the reasonable authenticity of the documents, they're not allowed to create additional burdens in the requirements. There's also an Iowa law called Services for Non-English Speaking Employees that requires certified interpretation at the work site on each shift with non-English speaking workers if at least 10% of the workers speak the same non-English language. And this law also has rules and requirements when it comes to recruitment of people from at a distance. So those are a couple sort of little known but important rights that are particularly relevant to immigrant and refugee community members. So the first law I talked about is enforced by the U.S. Department of Justice in what's called the Immigrant and Employee Rights section. And the second is under the purview, because it's a state law, of Iowa Workforce Development. The Iowa Division of Labor enforces the services for non-English speaking employees components. So to get back to the issue that Lata raised, and I do want to emphasize, actually, Lata, you had mentioned something that I didn't follow up on, which is the possibility of trafficking in one of the cases. And that is a criminal law. So that is not like many of these other laws are civil laws and involve perhaps repayment of lost wages or fines. Trafficking is absolutely a criminal law. And as you're probably aware, but I just want to underscore that and should really be looked at carefully with the assistance of a lawyer from that angle. So most of these laws we've talked about apply regardless of status. The anti-discrimination rights under Immigration and Nationality Act apply more specifically to people who are work authorized. But other than that, these fundamental rights apply regardless of status. The exception is that there are limitations in the remedies. So if you're fired, if a worker is fired for organizing, for example, the right to engage in concerted activity, which we didn't get to under the National Labor Relations Act, does apply, but their ability to be reinstated under that or other laws may be limited if it becomes clear in the course of the case that they lack status. So the employer still violated the right, is still charged with that violation, but the worker may not be able to be reinstated if that becomes clear through the process. I will just say the disclaimer, which is that there are memorandums of understanding clearly stating that the Department of Labor and EEOC will not share data with ICE and that ICE will not interfere if there's an investigation pending, but those are political decisions and that can change. And so at least over the course of the next couple of months, we just have to continue to monitor the status of those MOUs. I just want to also, as we wrap up, emphasize that it's incredibly important to know about these existing rights that cover perhaps more things than people realize they have protections around in the workplace. But there are critical gaps in the laws and enforcement of these laws that we also have to recognize. There are entire sectors of the economy that disproportionately employ Black, Indigenous, people of color that are subject to loopholes and exclusions. So agriculture to this day continues to be excluded from many protections under our laws. Domestic work continues to be excluded from many provisions of our laws. And those, I think really play a role in the reproduction of systemic racism in our economy and in our society, and are something that a lot of people are beginning to raise and address. There are important protections like the right to paid sick days that many workers who we would think, most would benefit from that. Restaurant workers who are handling people's food, right, very often don't themselves have paid sick days. And so some states have stepped forward and implemented those kinds of laws, but we don't have that in Iowa or at a federal level outside of the coronavirus related protections that were implemented for certain employers. And then funding for investigators and enforcement has really diminished to historic lows in some of the agencies like OSHA. And there are often few, if any, fines that are imposed. And so what the implications for that are, really that means that workers, community leaders need to play an outsized role in learning their rights, coming together to assert their rights, and and really engaging in the discussions about what our laws and policies need to be going forward to strengthen public health and to strengthen workers' dignity on the job.
Yeah, and I want to pick up where Robin left off and just say, clearly these, like any laws, these laws don't enforce themselves, but particularly in the world of labor and employment laws, there are no cops on the beat who are, searching around for violations. We find out about violations when people have the information and the understanding and the education to know what expectations they should have. And so I want to thank all of you again for coming, and just emphasize that your roles, your advocacy, and your ability to communicate and educate workers who you work with is really vital, because that's how people know and find out how to avail themselves of these protections, which are in place because we as a society democratically decided that these are the minimal expectations we should have of our workplaces. So we just want to leave with a mention of how you can keep connected with us and how you can find more resources. I put one of those links into the chat earlier for folks. Certainly you are welcome to call us. 319-335-4144 is our main office line. And our website, which is laborcenter.uiowa.edu, has a link to the Worker Rights Manual and more details about many of the laws that we talked about today. And don't hesitate to follow up with either Robin or myself for more discussion after this. Thanks.
Hey, Jennifer and Robin, can I ask a couple of really quick questions that I had come in? Hey, so when it comes to COVID in particular, then I know that there's been a lot of workplace safety concerns that have received national news attention from the state of Iowa, in particular with food production and meat production. And I just wanted to ask, one of the questions that had come in had been, if you've seen a difference in trends, for when March and April, when those stories were in the news, and people's exposure and lack of PPE or unnecessary exposure, or they're being sick, or losing loved ones or friends. Has there really, has there been a dramatic shift in policy or in workplace protections or in resources available for employees since then, or is it still pretty much the same?
So not a dramatic change in policy. We can say that very clearly. First off, we have not seen any sort of enforceable standard or guidelines from the federal or the state level. So that has meant that, to answer the other part of your question, there is an incredibly wide spectrum of conditions that people are working under. And I wish I could say that we are in a much better place than we were 5 or 6 months ago. But I think based on calls and questions and concerns and reports that we continue to get from people in workplaces ranging from manufacturing to healthcare to public education and everything in between, depending on where people work, conditions might have improved a lot because either workers were able to advocate for protections, and or employers wanted to do the right thing and keep their employees safe and healthy. And we also have lots of places in our state that are still on the other end of the spectrum. And I think we know that just, collectively from some of the news reports about new rounds of outbreaks that are workplace related happening right now in our state.
Okay. I would just add to that there's a false, I think, dichotomy created between everything has to be shut down and everything has to be open under the current environment. And I would just say that even in the absence of the federal standards, enforceable federal standards from OSHA, a lot of community organizations and experts have created, including CDC and OSHA, right, have created standards and sort of a blueprint of what should be happening that workers can really benefit and community groups can really benefit from reviewing, that are specific to each industry and could be asked of employers and even expected of employers, even in the absence of federal enforcement and state enforcement. And so COSH, the Council on Occupational Safety and Health, is one really excellent example of a website that brings together national experts and has fantastic resources in many languages for organizations that are industry specific and specific to the experiences in many cases of refugee and immigrant workers.
Yeah, and I want to emphasize that as well. It's not that we don't know much better 6 months, 7 months in what to do. There is a lot of excellent guidance that when employers follow it and when all of us follow it, we know the outcomes are better. Right. So public health experts and occupational safety experts have been working overtime for months throughout this pandemic, assessing and developing really excellent guidelines. So when I said there's no enforceable guidelines, what I meant was, just there's nobody requiring our institutions and our workplaces to follow this across the board, which is why we just have this huge spectrum of some places have made lots of improvements, and they really ought to be recognized and praised for that, and are following almost all those guidelines. And then, unfortunately, we know there are places that aren't.
Okay. And then another question, I think that you had responded to this already. Your website, though, the manual that you had referenced on workers' rights, is that in a printable format on your website, like a downloadable? Okay.
Yes,
Perfect.
it is. There's a PDF. Yep.
Yep, it's
Okay.
a free download of a PDF in English and Spanish. And if there are groups that would like to partner with us to make that available in other languages, we would really welcome that discussion.
Okay. You're probably going to get an email from me later about that in particular, too.
Great.
All right. Any other questions from our audience? Okay. Well, just to let everyone know, this recording will be available on the Rossi website for reference here. Give Valerie and I a good 24 hours and we'll get that up for everyone. And then you have contact information here for the Labor Center, and then also for Jennifer and Robin as well, for questions that you think of at 1 a.m, like I do.
Yes,
All right.
please. Don't hesitate to reach out. It was great to spend the day with you. And thank you, Stephanie, for all the incredible work that you do to put this together.
Sure. Thank you very much for being here, Jennifer and Robin. Thanks everyone for attending today. We really appreciate your time and for making sure that this information gets out to your communities.
Thank you. Take care.
Thank you.